In with some discussion. Gene Rossi and Roger P. Foley remain with me, along with Sanford Rubenstein. He's an attorney here in New York City. So, Gene, when you hear that 911 call, what's going through your head as you listen to that call?
What's going through my head is I can understand why they didn't find him guilty of first-degree murder. He puts in it he's an Army veteran. He has a carry permit. He's saying that Jimmy Shelton was going to rape Miranda. It has all the indicia of someone who has a arguably valid self-defense, and that's why they didn't find him guilty of first-degree murder.
So you're saying he shouldn't have been found guilty of it. You agree with that?
I can see why the jury did not find him guilty of first degree based on that tape. Absolutely.
Got you. Roger P. Foley, your assessment.
Well, I agree. I mean, obviously, there's a lot of anxiety in that call. There's the heat of the moment. He's giving a lot of information, but a lot of that information was very helpful to his defense team.
Exactly. Sanford Rubenstein joining me here in New York City. So
another key piece of evidence here was the testimony of Miranda. First, she testifies that she didn't need his help. Then when the defense recalls her, she admits that she said she didn't remember anything at a pretrial hearing. Certainly, a jury's going to hear all that and say, gee, I don't know whether I can find this person guilty beyond the reasonable doubt of any crime. Exactly.
When there's not proof beyond a reasonable doubt, it ends in an acquittal. We're going to move on now and listen to some testimony in this case from the medical examiner. Let's jump back in with our panel quickly on this. So, Roger P. Foley, criminal defense attorney, does that testimony help the defense or the prosecution more?
I don't think it did anything. I'm just wondering if the doctors ever have been shot before, because it could incapacitate you, whether it's a 22 or a 45. I mean, it can definitely incapacitate you. And yes, I understand the whole defense argument, whether or not he could have moved forward and would have been consistent with the defense, or had he not been moving forward and the actual defendant had come towards him. I don't think it tells us one thing either way, one way or the other, because the defendant already said he shot him and he gave the reasons on the 911 call. So I don't think the testimony helped or hurt.
Gene Rossi, it seems to me that this helps the defense a little bit more because, well, if it's possible that this guy was still moving forward, it explains why the defendant basically could keep shooting because he felt as though he was under attack.
Absolutely. You wanna feed that reasonable doubt beast, and you want to give it crumbs. I thought this medical examiner, it's not a home run, maybe a bunt signal, but I gotta disagree respectfully with Roger that if you take the Miranda testimony, the tape, and that he was shot, Jimmy Shelton was shot, but he could still move forward, that's consistent with a self-defense argument.
Exactly. Sanford Rubenstein joining me here in New York. So do you agree with my assessment on this, or am I off base?
I think what's really important here is if the shot really was from a downward angle, which was the defense was claiming, and the size of the victim was so much larger than the size of the defendant in this case, he was coming at him like a linebacker, which is what the defense said, then clearly it could all fit in a self-defense defense.
And that's what we basically had shape up here. It was self-defense of another, the girlfriend who the defendant said was being raped. You heard those words on the 911 call. And then self-defense of himself. This defendant, 25 years old, facing off against Jimmy Shelton, 44. Let's listen to a little bit more testimony now. That's the recording that the defendant made when he entered this situation, and you heard how the rest of it went down there. So Sanford Rubenstein, the state was turning around saying, hey, this is premeditated because this guy is riding in like some sort of superhero, going in guns blazing, trying to either impress his girlfriend or potentially protect her, but that makes him the initial aggressor here.
I think what he's trying to show is that the defendant, in fact, was angry. And at this point in time, the defendant has been not at the scene, but was looking through a window, and he saw what he thought was her being sexually abused by someone who has been sexually abusing her since she was 12, and he was out of control. Came down here and shot him. I don't know that helps the defense.
I don't think it does at all. I think that the state's theory in this, and I'll bring the rest of the panel in here now, Gene Rossi, after hearing that recording, who goes into a situation like that, recording and then guns blazing?
A man who wants to establish a self-defense when he calls the police on 911, that's who's going to do the recording. This guy kind of premeditatedly, according to my analysis, this murder, he knew exactly what he was going to do. He had the motive, the opportunity. He definitely had the means. And this was a well-planned attack. I have a feeling that the jury may have been engaged a little bit in jury nullification because they're saying, you know what? Maybe he did engage premeditatedly, but God, this guy was taking advantage of that girl. You know, he was not, St. Augustine. And you know what? He kind of got what he deserved. I guarantee you, in their minds, they were thinking that.
You know, that's what I was thinking as well, Gene. I agreed with that. Roger Foley, I think you were nodding your head in agreement as well, that you've got a victim here who is accused of absolutely disgusting behavior by a defendant, and it's not a sympathetic victim if you're to believe the defense.
Correct. You got a good-looking young man who's former military, who's got his concealed weapons permit, probably hasn't had any other prior history, criminal history. But when you listen to that tape, you say, oh, geez, where's the self-defense? Is it the defense of the other because he's molesting her? Or is it defense of himself? Because it's supposed to be self-defense, correct? So, again, I didn't hear this whole jury trial, and I didn't hear all the statements that were made, but I agree with your first guest there in studio. That definitely did not help the defense.
Yeah, it was a complicated case, and we're going to go through more of it when we come back here on the Law and Crime Network, because the key witness, of course, was the girlfriend, Miranda Goddard. You heard her voice in those recordings. She testified several times throughout this case. We'll listen to some of what she had to say after this break.